we're going to start, and it's to say good afternoon, everybody, good morning, good evening, wherever you're joining us from. Thank you very much for attending our second webinar of this academic year. And today what we have is we have colleagues from SOAS who do various work around the environment, business, and human rights, and to sort of engage with the ICJ climate advisory opinion. And we have Floriane, who is a partner at Withers, the New York office. So she's very early. It's really early for her. So a huge thank you to Floriane for moderating this panel. So Floriane had also participated in the submissions on behalf of, I think, Pakistan, and before the ICJ. So she does have a lot of experience. She does public international law anyway in her practice. What we've done is I have included links to each of our speakers and the moderator. So if you want a fuller CV and a fuller bio, please just click on any of those. We've also in the chat, there's a link to the advisory opinion. For those of you who haven't looked at it, it might be useful to look at it after this webinar and start with the summary, which is 40 or so odd pages for your reading pleasure. The way the webinar this afternoon will run is that I'm going to hand over to Floriane, and she would, she's already agreed with our panelists how they would run the webinar, and that's fine. I'll come back at the end to just tell us what our next webinar would be and to invite everybody. So, Floriane, over to you.
Thank you, Emilia, for this kind introduction. Good afternoon, everyone. It's a privilege to be here with you today to moderate this important discussion. Let me begin, of course, by thanking SOAS and Emilia in particular for convening us to reflect on the implications of the International Court of Justice recent advisory opinion on climate change, an opinion that marks a significant moment in the evolution of international law. As some of you know, last July, the ICJ issued a unanimous decision affirming that climate change is not only urgent, it is an existential threat. The court clarified that states must bear international responsibility if they fail to exercise due diligence, specifically by not enacting the necessary laws and regulations to limit emissions from private actors within their jurisdiction. This opinion is the result of a remarkable global campaign initiated by Pacific Island students and the government of Vanuatu, which ultimately brought together over 130 countries to request the court's guidance. The ICJ responded to that call, drawing on submissions from across the world to deliver an opinion that redefines the landscape around climate change. So what did the court actually say in that opinion? In broad terms, it confirmed that states have binding obligations to address climate change, not only under climate treaties like the Paris Agreement, but also under customary international law and human rights law. States therefore must act with due diligence and use all available means to prevent significant harm to the climate system. The opinion also sends a very clear signal to, and what is very relevant for our webinar, to states, investors, and fossil fuel producers. It states that failing to act, such as by issuing new fossil fuel exploration licenses, could constitute an internationally wrongful act and potentially give rise to compensation. In other words, permitting new coal, oil, or gas development may breach international law. The court further emphasized the rights of affected communities, noting that climate impacts can undermine a wide range of human rights. It warned that failing to implement timely and adequate adaptation measures could violate those obligations. In short, this opinion elevates climate actions from a matter of policy to one of legal accountability. Today, as Emilia said, we will examine those legal findings and really explore what they mean in practice for key stakeholders. And we will focus on three core dimensions: states, foreign investors, and local communities. And to help us unpack the implications of the ICJ's opinion, we are joined by three distinguished experts who bring deep insight and experience across those areas, starting with Dr. Birsha Ohdedar, who is a lecturer in climate change and environmental law at SOAS and Deputy Director of the Law, Environment and Development Center. Birsha's research focuses on environmental justice, climate and water law, as well as human rights. Next, Dr. Michelle Staggs Kelsall, Senior Lecturer in International Law at SOAS. Michelle has extensive experience before international tribunals and in particular in the field of business and human rights. And last but not least, of course, Professor Philippe Cullet, Professor of International and Environmental Law at SOAS. Philippe is a leading voice on environmental governance, water law, and climate justice. We will take a little less than an hour for our discussion, and of course, we will save a few minutes as well for questions from the audience. So let us start with our discussion with the implications of the ICJ's opinion for states. And I first turn to Philippe. In your view, Philippe, what are the key legal obligations the court has clarified for states? And how significant is it for investment disputes, in the sense of disputes arising from foreign investments, that those climate obligations are now recognized erga omnes, in other words, owed to the international community as a whole? Over to you, Philippe.
Thank you. I'm sure that's a question that could keep us busy for a few hours. So, okay, maybe just as an entry point, I guess the first thing that the court has done for us in a way is to confirm the idea that climate change law is not just the climate change regime, specifically in terms of what they want to tell us. It's also the Biodiversity Convention, the Desertification Convention, and human rights. What the court also does is to re-emphasize that certain principles at least, are part of what we need to fully integrate in our understanding of what we do with climate change. So among those ones, there is sustainable development, common but differentiated responsibilities, equity, and intergenerational equity. They also tell us that climate change treaties do not exclude customary rules or other treaty rules. So in a sense that it's not because we have one regime that we are not going to consider the rest, as well as the fact that the three treaties are not have no incompatibility between them, as argued by some of the people who made submissions. One of the specific things that the court tells us is that under the Paris Agreement, 1.5 degree has become the scientifically based consensus target. So certain specific things they try to bring as being what states have to follow, whether they like it or not. I guess one of the things that we see with that is what actually we knew. In the first place, the climate change regime in 1992, in its framework convention framing, was nothing but one environmental treaty among many other environmental treaties. In the meantime, there's been a lot of trying to separate climate change from the environment in a way. So now I think it's becoming clearer again, if there was a need for that there is no distinction or no real distinction that can be made. In terms of the implication for investment disputes at the level of states, the thing is that the court still speaks a traditional public international law language on the whole. So it doesn't really directly bring in private sector actors more than what would be the mainstream understanding of interstate relations, which makes sense. We know that, but that also means that it doesn't push the boundaries much further than what we already have. One of the things that will hopefully happen is that the broader understanding of obligations related to climate change will offer new entry point in relation to investment dispute and also ensure lesser resistance to environmental protection measures generally. In terms of clarification of obligations, I'm not so sure whether we really go much further than what we had. It's an amazing restatement. It's an amazing statement to the world, but it may be worth at the outset to remind ourselves of the separate opinion of Judge Yusuf that tells us that all that the court does is, here I quote, simply restate well-known customary rules and principles of international law and the provision of the climate change treaties relating to obligations of state. And there's several separate opinions that more on the fact that really the court has restated what there is, but not done as much as some of the judges would have liked it to do. I think I'll stop here for this.
Thank you, Philippe. And I'd like to thank you very much for your insights. I'd like to pick up on the fact that you mentioned the Paris Agreement earlier, and the court refused to consider the Paris Agreement as a self-contained regime or as lex specialis, and instead linked climate duties to human rights and customary international law. I'd like to turn to Dr. Birsha Ohdedar for this next question. How should we understand this part of the opinion? And does it strengthen or weaken the Paris Agreement in your view? How might this opinion influence the ongoing international climate negotiations or states' behavior under the Paris framework?
Thank you, Floriane. Yeah, I'll build on, I guess, what Philippe said at the outset. Yeah, as you kind of mentioned, the court refused this argument that the Paris Agreement was a self-contained regime. So the argument that climate change can only really be dealt with by the climate treaties. There was a small number of countries that argued this, but powerful ones like I think the US and Saudi Arabia were among the small group that argued on this point, but the ICJ rejected this, and they said that when they consider international law and climate change, it's not just about the climate treaties, but rather we need to consider the other environmental treaties that Philippe mentioned, for instance, customary international law, human rights law, and no one legal framework is kind of more applicable than the other. They kind of complement each other. Also worth mentioning that there were 3 advisory opinions in the space of, I think, 1 year, as in one from the Inter-American Court of Human Rights and one from the International Tribunal on the Law of the Sea, and it lost the Tribunal of the Law of the Sea, who had the same argument put forward to them, said essentially the same thing. So I think the 2 advisory opinions together kind of squash that that argument. So then how does it affect the negotiations? I think I can make a couple of brief points on this, and maybe we can come back to some of these points. But one, as Philippe already mentioned, was around this temperature goal. So in the Paris Agreement, there was a temperature goal that was put in around to saying that we need to hold increases in global average temperature to well below 2 degrees above pre-industrial levels and pursue it towards 1.5 degrees. This was very much in 2015 a compromise between least developed countries, small island states, and civil society who really pushed hard for that 1.5 degree language, and others who wanted 2 degrees or no degree target as such. So the ICJ really honed in on this and clarified that 1.5 is now the primary temperature goal. And it used further proceedings or conferences of the parties that have happened since the Paris Agreement to kind of justify that. It's also reflected in other litigation that has happened that has said 1.5 is the target. So that's quite an important step. We can talk about what that implications of that is further down the line on litigation. But in terms of the negotiations themselves, maybe one point worth talking about is nationally determined contributions, which are under the Paris Agreement, the thing that each country has to do, put forward what it's doing about climate change every few years, and that's meant to collectively take us to the goal. And there was always a kind of debate about what these NDCs need to look like. Is it completely discretionary for countries to do whatever they want? Is it completely voluntary, bottom-up process? Or are there specific things that countries have to do in terms of not just process, but actual content of these NDCs? So the ICJ, in a way, took a firmer stance on this in some ways, because it said that states don't have complete discretion about what they put in those NDCs. They can't just submit anything. Parties must exercise due diligence in putting forward the NDCs. So that means that you have to do kind of everything you can as a state to put forward your NDC, as well as it must reflect the highest possible ambition, and each NDC must be a step forward. They also said each of these NDCs, so when a country is coming up with what its contribution is, you must also be looking at what other countries are doing through what's called the global stocktake process. So that is a kind of every few years, the countries have a stocktake of what everyone is doing collectively towards the goal of 2 degrees or 1.5 degrees. And the last one in 2023 essentially said we are way behind on this. So in forming these NDCs now, countries have some standards in terms of what they need to do. Whether that's far enough in terms of saying, what those quantified emission targets, for instance, should be. Again, some of the separate opinions, such as Judge Youssef's one that Philippe mentioned, and other commentators have critiqued it in terms of saying it's perhaps not going as far in terms of saying what that emissions, when countries come up with emission target, what that should be in terms of, for instance, taking account of a fair share approach between different countries. A last final comment on that is, in terms of the negotiations, there's also a school of thought that the ICJ advisory opinion has kind of complicated now the negotiation process. And I guess the argument is, and I've seen it now from a few different commentators about that the fact that in international law negotiations, usually things like the Paris Agreement are a compromise, and so the language stays a little bit ambiguous. So for instance, well below 2 degrees and 1.5 degrees were both put in to reflect that compromise, and that's then sorted out through multilateral negotiations. And the court, by then interpreting it in a more strictly way, then has a freezing effect in those negotiations, because countries may be less likely to sign up to things in case a court then intervenes and interprets it more strictly. We'll see how that plays out. Essentially, we don't really know. I'm not hugely convinced of those arguments, because I think in some ways the COP has been running for 30 years and there's a lot of energy that goes into it, and whether that has gone far enough or whether that's been going fast enough, I think is very questionable. So things that can disrupt that ecosystem, I think, are necessary at this stage.
Thank you, Birsha. And as you said, climate duties are binding, and that's obviously what the court has reminded us. The court also raised the prospect of reparation for those harmed, which is also very critical to the opinion. And I'd like to next turn to Michelle. From a human rights and global South perspective, do you think that this could open the door for climate vulnerable states to invoke international responsibility and claim remedies for climate change?
Well, I thank you, Floriane. I think the short answer I would give to that question is that the door may not yet be open, but the ICJ advisory opinion provides a key, an important key toward unlocking it. That being said, I agree with my co-panelists that the court's opinion as a whole did not go far enough in delineating separate and differential responsibilities of states per se in this particular context. And per Judge Yusuf's separate and dissenting opinion, I think they could have gone much further in terms of articulating and delineating both the historic harms conducted by a variety of states who are at a stage of development now that has precipitated and resulted from greenhouse gas emissions over a much lengthier period, in addition to those most vulnerable in the current moment, including the island states and such as Vanuatu and St. Lucia, who first brought this opinion, of course, at the behest of a wonderful social movement of students. So all of that being said, what does the opinion do, and how does in effect give some voice to the possibility of invoking international responsibility and claims for remedies for climate change, as you have suggested? Well, while the court was careful not to exercise overreach in the implications of ongoing emissions of greenhouse gas emissions from individual states' perspectives, it did assert that the issue was one of separate and differential responsibilities between states, depending on these historical aspects. So it does actually state that that should be something taken into account. While it didn't make a general pronouncement determining how and in what manner these responsibilities could be attributed to individual states, it notes that that responsibility on a case-by-case basis needs to assess the alleged wrongful conduct of particular states, both in terms of attribution and causation under the Articles of State Responsibility. One of the things that I think is interesting from a human rights perspective, where the court does try to extend, or to some extent follow in a trend of extension of human rights responsibilities, is in the extraterritorial obligations of states. And here the court was very clear in saying that in respect of climate change and human rights, it's no longer simply a question of territorial jurisdiction. In other words, it's not solely in the court's opinion that individual states are responsible for securing a reduction of anthropogenic GHGs within their own territorial borders. And it comes out very clearly in paragraphs 394 to 404 of the opinion. Here the court makes it clear that the travaux preparatoires of the International Convention on Civil and Political Rights did not intend for states to escape from their obligations outside of their own territory. And this would include, of course, the right to life under that convention. And it reiterates that the extraterritorial application of that convention in a series of its own advisory opinions can now be extended to include obligations in respect of climate change. It also takes into account the adverse effects of climate change on the enjoyment of human rights more generally, and considers that the full enjoyment of human rights cannot be ensured without the protection of the climate system and other parts of the environment. So in short, I think that it's important to note here that there has been an extension or an ongoing affirmation that it's not solely states looking into their own obligations for their own parties within their jurisdiction territorially, but also that they have to look beyond their own borders. And second, and related to this first observation, the court also emphasizes that states' obligations are both intergenerational and differential. So all international law is guided by the principles, as it states, and Philippe mentioned, of sustainable development, common but differential responsibilities and capabilities, equity, and intergenerational equity. And this would include human rights law obligations. I think a key aspect for claiming reparations for states will be determining how, in effect, to ensure attribution of responsibility and causation. And with regard to attribution, the key test here is actions or omissions on the part of a state that cause significant harm to the climate system in breach of an international law obligation. So that's going to be how I think individual member states are going to have to start to reason and think through the kinds of actions they may wish to bring toward the ICJ in future. Additionally, I think an aspect of the claim of reparations with respect to individual rights holders will be determining the aspects that enable existing regional human rights courts to grant rights holders the right to a clean and healthy environment in their favour. Of course, this will be after exhausting all domestic remedies, but as I will discuss briefly in later comments, there are some positive developments here, both in the African Court on Human and People's Rights and the Inter-American Court on Human Rights, as well as the European Court, moving toward this direction of stronger pronouncements in relation to the right to a healthy environment as it relates to climate change.
Thank you, Michelle. So we talked about implications for states. Now I'd like to turn to the implications on foreign investors and businesses. And for that, Michelle, I'd like to maybe stick with you for one more question, if you'd like to bear with me. One striking aspect of the ICJ opinion is its emphasis that a state's failure to take appropriate action against emissions from companies could constitute an internationally wrongful act. Again, sort of building on your expertise in business and human rights, how do you interpret this in terms of corporate accountability? Could this opinion spur stronger domestic regulations on businesses or influence initiatives like mandatory human rights and environmental due diligence for companies?
Thank you again, Floriane. Now, as Philippe mentioned at the beginning of these discussions, he's absolutely right in saying that the ICJ, in its opinion, very much remains in the frame of public international law and very much situates any corporate obligations vis-a-vis the state, ultimately with the direct responsibility being attributed to states themselves. This being said, however, I think the International Court of Justice in this opinion is really aligning itself with recent trends in the jurisprudence of regional human rights courts, through which those courts now acknowledge that states have an obligation to regulate private actors, as you say, in the conduct of human rights harms resulting from levels of toxicity in the environment. And the court here referred in particular to 3 cases in its analysis, the most notable of which is perhaps the La Oroya case from the Inter-American Court of Human Rights against Peru, through which the court determined that states must establish regulations requiring companies to implement actions aimed at ensuring respect for human rights recognized in various instruments, including that businesses must ensure their activities do not cause or contribute to human rights violations, such as the right to a healthy environment. So with respect to how this might be interpreted in terms of future corporate accountability vis-a-vis human rights, it's true that the opinion is less forthright in terms of direct accountability. And in that respect, much of the legislation that we're seeing passed throughout the globe is in relation to corporate conduct of due diligence in this regard. Now, that's, of course, an obligation of conduct rather than one of result. We can mention here, of course, France's Voie de Vigilance law and the German Supply Chains Act, in addition to, of course, the Corporate Sustainability and Environmental Due Diligence Directive at the EU level, a regulation that's been passed in addition to the EU's Corporate Sustainability Reporting Directive. Some of the concerns raised, however, with regard to this form of legislation has been that to date, many states are in effect attempting to streamline that legislation and reduce the requirements on corporations themselves. So in regard to the EU at the moment, what we're seeing is an omnibus regulation being issued, which will reduce the number of companies that have to engage in the conduct of human rights due diligence. And about 80% of companies within the EU's jurisdiction are no longer going to be captured by the directive in question. So this raises a number of concerns with respect to whether or not the ongoing attempts to secure human rights obligations on the part of private actors vis-a-vis climate change in particular, and the emission of greenhouse gas emissions is going to be able to be put into place other than in relation to regulatory and reporting requirements, which essentially don't result in substantive changes to the way in which corporations engage in business vis-a-vis the legislation. However, I'm still hopeful that there may be possibilities and aspects of this that will, as a result of this opinion, ensure that that is not merely a face-saving device for corporations, but and in effect is responding to the problem that we now see in effect is existential.
Thank you, Michelle. And of course, in this regard, the relationship between climate action and investment law is a critical issue. We've seen fossil fuel investors using investor-state dispute settlement, ISDS, to challenge climate policies, for example, suing over coal phase out or permit cancellations. In that regard, the opinion sends a very clear message that states have a legal duty to enact ambitious climate measures. But it seems that, of course, that could impact the legitimate expectations of investors in carbon-intensive industries and, of course, and the stability of the overall regulatory environment. Philippe, if I may ask, what do you think, could the opinion strengthen state defenses when taking regulatory climate-friendly initiatives?
Hopefully so. But the starting point is that at the level of dispute that arise within the context of an existing agreement, the states are still largely bound by the provisions of those existing agreements. So it's helpful, but typically the advisory opinion could have been more helpful if instead of reinforcing sustainable development as it has been for the past several decades, had tried to give us an interpretation which would be more environmentally friendly in a way, which we don't have. The issue is also probably largely in a north-south context, even though it's global. In the context of South-North disputes, which global South, global North disputes, which are also often the most controversial in terms of those outcomes. Here we go back again to, okay, here it's another one I'll just highlight. It's a separate opinion of Judge Sebutinde, who specifically says and drafts the paragraphs that she says should have been added to the advisory opinion that would have stated that in relation to common but differentiated responsibilities, states in Annex 1 of the Framework Convention have additional obligations, which is not something that we have. So the answer is yes, but it's yes because of the legitimacy that something called an advisory opinion of the ICJ has per se, but not necessarily in terms of what the substance of what we've been given does. Now, there is a second part to this, which is what about the new flexibility or new power that it gives to state in terms of drafting new agreements? And in the current context, we know that there are lots of bilateral investment or free trade agreements that are being negotiated. So in this context, what I would see is probably a re-emphasis of some things that has been happening, that has been growing over the past number of years. And one example we have that it's something which was already there and which will be hopefully helped by what has happened this year is this Sustainable Investment Facilitation Agreement between the EU and Angola of 2023, which already goes quite a bit further than what we've been used to in terms of its objective being both economic diversification and sustainable development. And within that, there is a recognition, for instance, that multilateral environmental agreements are important. Fine, maybe important is not enough, but that's a starting point. And that mutual supportiveness is something that needs to be integrated in terms of looking at investment. That again may not be enough in terms of giving nature or the environment priority, but at least it's a new kind of language being used in terms of investment treaties.
Thank you, Philippe. Now, building on the investor aspect that we've been talking about, let's really drill down a little bit more on climate litigation. Birsha, to what extent do you think that this opinion will influence litigation strategies, particularly on the investor side? And going forward, how do we align investor rights with state climate duties so that protecting the climate is not automatically treated as a breach of investors' rights?
Thank you. Yeah, I build on what Philippe and Michelle have started on this line of questioning. Yeah, so it's in some ways the court said very little about, as mentioned, about kind of private actors, and it's still seen through the kind of state, and very little about this increased interaction between investment treaties and climate change law or issues of climate change. But we know this is a big issue in relation to fossil fuel transitions, for instance. And the ICJ advisory opinion does confirm that international laws requires states to protect the climate system. They have these obligations to, which includes a duty to regulate private sector activity. It also framed this in a broad way. So it wasn't just fossil fuel production, but also consumption, licensing, subsidies, and so on. So for instance, a state like, for instance, Australia, for instance, which exports a lot of coal, the fossil fuel emissions might be from somewhere else, but it still has a duty, even though it's exporting that natural resource. And failure to kind of curb that becomes an international wrongful act. So on the one hand, it does provide an emphasis for states to then do more. And when it comes to the investor side, particularly when it comes to first generation investor treaties that exist, you have this problem where they're so badly skewed on the investor side in terms of giving investors a lot of power. More recent ones, like Philippe mentioned, have specific carve-outs for environment and climate change. Even if they don't go far enough, it's a starting point for a discussion about how to balance things out. There are questions now, I guess, when it comes to investor-state arbitration, and there'll be others in this room who are work much more closely on this area. But when it comes to questions like whether the investor has a right to fair and equitable treatment, there's the idea of legitimate expectations. So if a state takes strong action in relation to, after the ICJ advisory opinion, to, for instance, phase out fossil fuels, ban fossil fuels, have fossil fuel moratoriums, can an investor still argue in 2025 that this is completely unexpected? And does it also change for instance, when it comes to renewable energy, the similar arbitrations that have happened in relation to renewable energy policies? So there have been other arbitrations where a state has removed renewable energy subsidies and an investor has taken action, right? So does that change things in those types of arbitrations? And how will the tribunal rule on these questions and take into account the ICJ's advisory opinion? I think the weight of the ICJ's opinion hopefully will filter through to those tribunals and to those dispute resolution systems so that it can be taken into account. But I guess there's a bigger question there about the fundamental question of this whole system, the whole investor-state arbitration system, which has now, over many decades now, there are something like 2,500 bilateral treaties, I think, and for many decades has essentially provided a hierarchy for investor rights to be recognized ahead of states and people's rights. And we're seeing this now having an effect on our whole, global climate system. So there does need to be, in a way, a lot of reform to that system and an undoing of that system, probably through a multilateral process, which kind of undoes all of these kind of messy bilateral treaties and has a system which can go forward with the world that, to tackle the challenges that we see. Yeah.
Thank you, Birsha. So we talked about implications for states, implications for investors and businesses. Now let's turn to implications for local communities and climate justice. And for that, I'll turn back to you, Michelle. A core promise of the ICJ opinion lies in advancing climate justice and human rights. And of course, that's a core area of your expertise, Michelle. The court explicitly recognized that climate change impairs the enjoyment of fundamental human rights, including the rights to life, health, and adequate standard of living, the rights of women, and even the rights to a healthy environment. How can local communities and civil society leverage this opinion to advance their causes? And really looking ahead to litigation strategy, what types of claim do you think are most likely to emerge and in which forum?
Thank you, Floriane. A very big question, of course, as I unmute myself, and one that doesn't have any easy answers. I mean, I think it should be noted first and foremost that the advisory opinion itself is the result of student activism and action, and is the request came from, of course, initially 27 students leading a campaign on this issue from the University of the South Pacific in Fiji, and the Pacific Island Students Fighting Climate Change, subsequently formally taken up by Vanuatu, and the General Assembly adopting the resolution for the formal opinion. So I think this in and of itself already shows the huge achievement, and one which warrants pause to consider how additional questions may yet be posed both to the International Court of Justice, utilizing bottom-up approaches, and also other avenues for advocacy and strategy. I think in terms of leverage from the opinion itself, holding businesses and states to account through aligning advocacy campaigns now with the unanimously agreed requirements of the advisory opinion could be of some use to civil society organizations and social movements across the globe. One aspect which I think which has been less thought through, but which for me, to my mind, was something that might be worthy of discussion amongst the advocacy community and social movements in particular, is how does the court's methods in terms of assessing the science that's relevant to climate change affect any advocacy strategy? I think there's a lot of leverage to be had for starting to think through alignment with scientific groups, for example, those working in the environmental sector, rather than seeing human rights as somehow separate and distinct from the various other aspects of climate change that now are front and center thanks to the advisory opinion and its decision, and the way in which it tried to, I think, and successfully undertake a much more holistic approach to the way in which international law in these various aspects can be seen as working together. I think also noting that sea level rise is likely to have adverse consequences for states, particularly small island states as it did, and low-lying coastal states, leading potentially to forced displacement, may mean that it could be a good advocacy tool also in terms of migration and advocacy surrounding migration and the rights of different communities, particularly communities which are likely to be rendered stateless by the impact and effects of climate change. And here I think Judge Charlesworth's separate and concurring opinion also further acknowledges the differential impacts of climate change and the need for both an intersectional and holistic approach, which I think advocacy organizations can then utilize to discuss the differential impacts for specific groups they're looking to legitimate the rights and promote the rights for. In terms of litigation strategy and what claims I think are most likely to emerge and in which forums, I think there are ongoing trends which the advisory opinion adds further weight to. And here I think the two key fora continue to be regional human rights courts. Obviously, we need to ensure domestic remedies are fully exhausted, but sadly, in most instances, even when they are, the results are not so forthcoming from various states. So I think the advisory opinion can add further weight to claims such as those which have already gone through the African Court of Peoples and Human Rights, for example, in relation to trafigura and toxicity emissions in Côte d'Ivoire. And then also, as I've already mentioned, the case against Peru in the International Court of Human Rights, Inter-American Court of Human Rights. But in terms of transnational tort litigation, I guess one of the key cases that has most recently emerged in the UK has been that of Okpabi and others versus Royal Dutch Shell. And of course, the case involving Shell in Nigeria and the UK recently had a judgment this June in 2025 with a significant development here, which of course my colleagues in environmental law will know much about. And there the High Court in London ruled that Shell and its former Nigerian subsidiary could be held legally responsible for historic pollution in the Niger Delta. So I think here the advisory opinion, again, in relation to intergenerational accountability may be another aspect or another piece of the puzzle through which litigation can be brought through the courts with respect to how that intergenerational accountability should really be front and center in the manner in which companies, particularly fossil fuel companies, are made to be or asked to be responsive to the various harms that have been subject to the populations in question.
Thank you, Misha. I'd like to really build on what you just explained and turn back to you, Birsha. In your opinion, how will the opinion from the ICJ empower local communities and civil society using these findings to demand stronger action or support from their governments or from other states, perhaps those with the highest volume of carbon emissions?
Thanks. Yeah, so I guess the starting point is that the ICJ's the ICJ's advisory opinion does have a certain amount of legitimacy, partly because of, obviously being the ICJ, but also the record level of participation and engagement that this had. So it's kind of seen as as one which carries a lot of weight. How will it be used by civil society, local communities? I think the primary way that you'll see it being used is maybe legal activism at the domestic level. And this is likely to happen through, this growth of climate litigation that has happened over the last 10 or 15 years. And the ICJ's, for instance, one thing that we could go back to in my initial comment was the ICJ's clarification of this temperature goal to 1.5 degrees. And it reinforces some of the arguments that were already emerging in cases around the world, such as the Swiss case Clima Senioren before the European Court of Human Rights, which emphasizes the need to limit warming to 1.5. So that means that when there is litigation against a particular action that a state is undertaking, whether it's an infrastructure action, for instance, it could be a new runway, for instance, which there was litigation in the UK about, or the state's nationally determined contribution, climate plans, using that as a marker for assessing whether that's enough will start to be reinforced. Civil society will probably also look to use the ICJ opinion to demand stronger climate policies in terms of taking part in the formulation of ambitious, progressively increasing climate commitments, which the NDC which the NDCs now need to be, which the ICJ clarified rather. So this gives communities a basis to push for, more climate legislation, halting fossil fuel exploration, more adaptation planning. And then in terms of high emissions, or those with the highest volume of emissions, I guess by linking climate obligations to broader international law, human rights, customary international law, it again provides hooks for civil society to call for high emission states to take stronger actions. So those in the global north countries to tell their kind of states to take more action. In saying that, the ICJ opinion did have a few gaps which were mentioned in this last hour or so. One was it didn't, so if you compare it, for instance, to the Inter-American Court's advisory opinion, the Inter-American Court actually highlighted intra and interstate inequalities more explicitly, and it explicitly noted about how 90 companies are responsible for something like 70% of emissions in the last 3 decades. The ICJ didn't really go into that disproportionate responsibility of corporations or things like wealth inequality, which the Inter-American Court highlighted. We already talked a little bit about how there were separate opinions. One of them also discussed about historical emissions. There was not a huge amount of discussion about historical emissions by certain countries and certain corporations that the ICJ didn't address, and also the structural inequalities by states, which again, Philippe has already discussed a little bit about the separate opinions talking about that. But yeah.
Thank you, Birsha. And I agree that, the ICJ opinion seems to really raise the bar for governments in supporting those most affected by climate impacts. Philippe, one final set of questions for you before we open the floor for Q&A. In practical terms, what impact do you think this will have at the local level? For example, beyond the NDCs that were mentioned earlier, could courts or policymakers be more receptive to claims from local communities for things like climate adaptation measures, disaster relief, or protection of resources because of this opinion?
Well, we hope so. The first thing is, I guess, because we're talking local level, each local level will offer a different kind of response, and that's actually what we would like to hope, that it won't be a uniform response. So probably I can't give an overall response right now. What the advisory opinion does is probably add a new layer of argumentation for social movements, for, let's say, claims of communities displaced by fossil fuel activities. But at the same time, maybe not new arguments for the same people or for similarly placed people affected by renewable energy projects. And that again is where hopefully the understanding of climate as not being separate from environment, and where then issues of displacement related to development activities within the context of sustainable development can be taken forward a little bit better. That will also surely help the claims of individual and communities affected by climate harms. At the same time, this is not only this is international law, plus this is soft in many ways, and that resonates differently at the national level in different countries. It will probably have more of an impact in countries where this goes alongside the direction of overall policy making in relation to the environment and climate change. And it may not do as much where the general direction of policy making is not so clearly aligned. In other words, it may be more welcome in certain contexts than others, and maybe that's where it will be less welcome, that it's most needed. At that level, maybe one of the things that we would have wished for is something that's been highlighted by many people over the past 2 months, is that there's been, in terms of local communities, in terms of affected people, there's been a whole discourse around climate justice that has developed over the past couple of decades. Climate justice is not something that the court really engaged with. Okay, we can read it into what it did. We understand why, again, and that's what Michel also covered, that it needs to stick within the boundaries of what it's supposed to cover to also ensure legitimacy of the advisory opinion among its own member states. But in terms, now that we're talking about communities or affected people, the frameworks that we have at present needs to be broadened, and there's been a lot of work done around that. And then maybe what the response will need to be is to be able to link those discourses that have grown over time, that have linked human rights, environment, climate change, in terms of something that fits within the context of the advisory opinion beyond the strict words that we have in front of us.
Thank you. Thank you very much, Philippe. Emilia, we do have a couple minutes, I think, for any questions from the audience. We also have one concluding question for all the distinguished speakers as well in reserve that we can use. We're entirely in your hands.
Thank you so very much. We haven't been monitoring the Q&A. We haven't received questions yet. The other thing is, and there's no, okay, so people can,
we have one
please feel free to raise your hand, and I'll hand back to you, Floriane.
Thank you, Emilia. Michael, the floor is yours.
But firstly, thank you very much for such an absolutely kind of fascinating presentation from each of you. And this absolutely isn't an area that I have any expertise in, but I'm just interested in relation to the ICJ's jurisdiction and its wider reach, whether there's any read across between this case and the ICJ case regarding Israel.
Who wants to take that question?
Michelle, you seem to be. I'm not sure. I'm not sure that I have an answer. So
yeah, I'm not sure I fully understand when you say read across. I guess what you're asking is to what extent does the advisory opinion on climate change and the environment have a place to play, an impact on, or will it be part of the precedents that are taken into account in the case of South Africa against Israel? Is that what you're asking in terms of how would it affect perhaps the court's understanding or interpretation of acts which in respect of the ongoing plausible risk of genocide, once that comes to deliberation by the ICJ, to what extent the destruction of the environment would take into account this opinion? Is that the question, or is it something else? Sorry.
I think it's a slightly broader question than that. I mean, part of what interested me in about the webinar today, was this sense of the and I think Philippe talked about the extent to which the bringing in of private sector actors and obligations on private sector actors. And I think at the edge of this judgment, there is a sense that even when using the language of public international law, that there may be implications of that on private actors. And I'm wondering to the extent to which that very edge of this case is also relevant to the case to which you refer of South Africa and Israel regarding plausible genocide. The possibility for the ICJ to create obligations that don't just relate to states, but relate to other entities. And I'm sorry if that isn't put very crisply, but it's sort of part of the penumbra of the case, I think.
Yeah, I think the challenge and difficulty continues continues to be in relation to the way and the manner in which the ICJ assesses its jurisdiction or its ability to comment on what the role of private actors. To date, it's been very much as maintained in the penumbra, as you suggest. There's been, since Barcelona Traction, really no real sense that they're willing to take into account private actors as being themselves having international legal personality to the extent that they can be bring cases to the court, nor is there any claim that for much of their jurisprudence to assess the role of private actors directly as a matter of public international law. Now, of course, there is an ideology around this, and we can talk about the distinction between public and private and what that means in respect of how the court assesses the implications of what private actors do. And I think many of us would like to see stronger pronouncements from the ICJ, if not directly against private actors, at least to begin to assess certain of these the violations as being norms of jus cogens. So one of the things I was going to raise in my concluding remarks was that we have an obligation erga omnes in respect of climate change and environmental degradation and the environment now, thanks to the ICJ's advisory opinion, but it doesn't actually specify the specific particular norms that are absolutely prohibited in this context. So one of the innovative or perhaps more creative things the court could have done is talk about what that prohibition might look like. It didn't do that. It's not surprising that it didn't do that because the court in general is quite, wants very much to remain within the parameters of a relatively conservative response to these issues. But, something like an absolute prohibition against environmental degradation to the point of species extinction. It's a very long norm, but something along those lines, had the court pronounced that based on the evidence at hand, would have been wonderful. But it's far more creative than in general the court to date has been. I don't know if my colleagues wish to disagree with me on that, but in general, I have a sense that the court has been largely conservative in its approach toward making pronouncements of the international law as it might yet be, much more focused on the law as it is, so to speak. Philippe and
No,
Birsha,
definitely no disagreement. Since you were talking about the edge of the case, maybe just one more thing. What maybe I think what Michel also indirectly refers to is that maybe in terms of an advisory opinion, we might have hoped that the court would say a little bit more than it would be able to do in another case, and that's where probably it did not do as much as maybe it might have done some years ago, some decades ago, who knows.
Floriane, there's a question from Sophia Mancini,
yes,
and
indeed.
she says, in your opinion, how does the ICJ's climate opinion affect dispute resolutions that are carried out by alternative means? I am specifically thinking about China's ISDS practice, which usually takes place outside formal ISDS systems. And she says the question is directed to anyone who wants to answer. And Sophia, please, if you prefer to unmute and speak, that's absolutely fine. Hopefully I read that clearly.
You did. If there's any clarification needed, I can say.
Please go on. You might want to add a few more to clarify.
So we've talked about how what the ICJ's climate opinion might mean for the ISDS system, and so how So what it might mean for the court cases, essentially. But with the unstable territory that is ISDS now, with the fact that it's so contested, with the fact that different actors are coming up with their own ways of reforming this system, it's not all cases go through the courts. And I personally study China's ISDS practice, so that's why it's of interest to me to see. They usually tend to solve investor-state disputes by alternative means, both the disputes that involve their own investors and disputes that involve other investors on their own, on Chinese territory. And I'm wondering what effect does it have, if any, this climate opinion on these kinds of dispute resolutions?
Okay, I don't have an answer. I don't know if my co-panelists have, but I guess the general answer is that what the advisory opinion may hopefully do is that it may give concerned actors, whether private or state, depending on who is on which side, new types of argument and legitimacy to put a certain type of agenda compared to what's happened until now. But if it's outside of those formal processes that we know, it's likely to be slightly more remote to the extent that one can give a very general answer.
That makes sense. Thank you.
I can't see any more questions. Yeah. So.
Emilia, do you want to conclude with, well, I'd like to maybe just conclude by thanking all of our speakers, of course, and again, thanking you, Emilia, for organizing, and of course, thanks to the audience for their participation and their questions. I understand that there is a webinar, the next webinar by SOAS also that will be announced, so happy for you to make the announcement, Emilia.
Okay, great. Thank you so very, very much. So if people are not aware, Philippe, Michelle, Birsha, we're all colleagues here at SOAS. So they all teach and they do research, excellent teaching and research here at SOAS. And so a huge thank you for accepting the invitation from the center to sort of explore this very, very interesting advisory opinion. Floriane, thank you. Thank you so very, very much for accepting our invitation to moderate this for us and bring in that practitioner perspective to the discussions. A huge thank you. There are lots of our management committee members of the center on the call. Martin is here, Michael, that you heard from as well. So thank you very, very much for joining. Our next webinar is next week. It's in the chat. Is next week, Tuesday. We're going to continue with this theme of ISDS that Sophia has raised now, and we're going to be exploring stabilization clauses in state contracts. And it's going to be where I'm going to moderate that webinar. And our speaker is Professor Annie Rajput, who is also affiliated with Withers here in London. But we both sit on the UNIDROIT working group that is reforming international investment contracts. And myself and one of our former students, who's a partner in an Indian law firm, had done a paper, a publication recently on stabilization clauses and what we think. Which is not very favorable, as some of you can imagine. But anyway, that is the webinar that we have next week, Tuesday at 6 p.m. And not a launch webinar. Thank you so very much.